Bad news. Your boss just handed you a performance improvement plan, also known as a PIP. Maybe it came out of nowhere. Maybe you saw it coming. Either way, you're probably wondering the same thing most people would wonder in that moment. Is this the beginning of the end? Here's what I want you to know before anything else. Getting a PIP does not automatically mean you're getting fired. But it does mean you need to start thinking about this differently, right now. I'm going to show you exactly how an employment attorney looks at a PIP, what it really means, what your rights are, and what to do in the next 48 hours. Here's exactly what you're getting in this video. First, I'm going to break down what a PIP actually is and the 3 different types, because not all PIPs mean the same thing. Second, I'll walk you through 5 things you should do right now to protect yourself. And third, you'll get your to-do list, the specific steps to take before your next meeting with Human Resources. If you find this useful, please hit subscribe. I put out a new video every Tuesday on the legal stuff most employees don't know they need to know. I'm a lawyer. I've seen how this plays out from both sides. Now let's get into it. Insight number 1. Let's start with what a PIP actually is. A performance improvement plan is a formal written document your employer uses to put performance concerns on record. It identifies what they say the problem is, what they expect you to do differently, a timeline, usually 30, 60, or 90 days, and what happens if you don't meet those expectations. Here's what most people don't know. A PIP is not required by law. No federal or state statute says your employer has to give you a PIP before firing you. In an at-will state, they can even let you go without one. So then, why do employers use them? 2 reasons. Number 1, some employers genuinely want to give you a path to improve. Or number 2, and this is the one most people don't want to hear. A PIP creates a documented paper trail that protects the employer if you later claim your termination was discriminatory or retaliatory. I've seen both kinds. I've seen PIPs that were genuinely meant to help someone turn things around. And unfortunately, I've seen PIPs that were written the week before someone was already going to be let go anyway. Knowing which kind you have changes everything about how you respond. Insight number 2, the 3 types of PIPs. Which one do you have? When I look at a PIP situation, I think about it in 3 categories. Type 1, the genuine PIP. The performance issues are real, the goals are specific and measurable, the timeline is reasonable, and the employer is actually providing support. This type of PIP is a warning and an opportunity. If you meet the goals, you keep the job. These do exist. Type 2, the pretextual PIP. The timing is a little suspicious. Maybe you just returned from medical leave, maybe you recently filed a complaint or reported something, or had a conflict with your manager. The performance issues are vague or inconsistently applied. This PIP may not be about performance at all. It may be about building a case. And type 3, the predetermined PIP. The employer has already decided to let you go. This PIP is a formality. The goals may be deliberately unrealistic. The timeline may be impossibly short. This is the PIP that exists to document a termination that was already decided no matter what you do next. Here's the important thing. You may not know which type you have right away, but the type matters enormously for how you respond. We'll get to that. Coming up in a second is a visual graphic of the 3 types of PIPs we just went over, along with more thorough details for each one. Insight number 3, what you shouldn't do. Before I tell you what to do, let me tell you what not to do. Because these mistakes are more common than you'd think, and they can cost you everything. Do not quit. I cannot say this strongly enough. Quitting the moment you receive a PIP is almost always the worst mistake you can make. You lose your income. You may disqualify yourself from unemployment benefits, and you give up any legal claims you might have had. Do not sign anything that says you agree with the performance assessment. Your employer will ask you to sign the PIP. Sign it to acknowledge receipt only. Write this under your signature. Signature indicates receipt of this document only. I do not agree with its contents. Doing this preserves your right to dispute the characterization later. Do not vent on Slack, email, or any company system. Assume everything you send on a work device or through company channels is visible. We did a whole video on this. The link is in the description. Do not ignore it. Even if the PIP feels unfair, ignoring it gives your employer exactly the paper trail they need. Show up, engage, and document everything. And do not negotiate a mutual separation without talking to an attorney first. I've seen people sign away significant legal claims for small severance packages just because they didn't know what they had. Insight number 4, your legal rights. Here's what your employer is not going to tell you when they hand you that PIP. Your legal rights don't pause because you're on a PIP. Every single protection you had before, whether it's Title VII, the ADA, the ADEA, the NLRA, those protections are still fully in effect. You cannot be placed on a PIP in retaliation for protected activity. If the PIP arrived shortly after you filed a discrimination complaint, requested a medical accommodation, took FMLA leave, reported a safety violation, or discussed wages with coworkers, the timing matters. That is evidence. Document it. You have the right to request a written copy of the PIP. If you don't have one, ask for it in writing. You have the right to submit a written response to the PIP. This is important. If anything in the PIP is factually incorrect, things like wrong dates, wrong projects, mischaracterized conversations, you can and should put your disagreement on the record in writing. Keep it factual and professional, not emotional. If you have a disability that is contributing to the performance issues identified in the PIP, you have the right to request a reasonable accommodation under the ADA, or the Americans with Disabilities Act. Your employer is required to engage in an interactive process to identify what the accommodation might look like. And if you are in a union or have an employment contract, then your rights might be significantly stronger than at-will employees. Check your agreement. Insight number 5, how to respond step by step. Here's how to actually respond to a PIP if you want to protect yourself. Step 1, read it carefully. Every word. What are the specific performance deficiencies cited? Are they measurable? Are the goals realistic and the timeline given? This assessment tells you which type of PIP you're dealing with. Step 2, document everything from this point forward. Save every email, keep notes of every conversation, date, time, who was present, what was said. I've seen employees win disputes and collect severance because they kept meticulous records. And unfortunately, I've seen others lose claims they would have won because they had nothing written down. Step 3, submit a written response if anything in the PIP is inaccurate. You have the right to put your version of events on the record. Keep it factual. Address each point specifically. Sign it as your response, not as agreement with the PIP itself. Step 4, meet every deadline. Request every check-in. Confirm every interaction in writing. Per our meeting today, I understand the expectation is X by date Y. This creates a record that you engaged seriously with the process. Finally, step 5, consult an employment attorney. You don't have to hire one. Many offer free initial consultations. But if you believe your PIP is retaliatory, pretextual, or discriminatory, or if a separation is being offered, you need someone who can evaluate your specific situation before you sign anything. As promised, here is your to-do list. 5 steps, start today. Step 1, do not quit and do not sign anything today. Take the 48 hours you need to think clearly before making any decisions. Step 2, sign the PIP for receipt only. Under your name, write, signature indicates receipt of this document only. I do not agree with its contents. Step 3, note the timing. When did you receive the PIP relative to any protected activity? Leave, complaint, accommodation request, wage discussion? Write it down today while it's fresh. Step 4. Submit a written response to any factual inaccuracies in the PIP. Factual, professional, dated. Keep a copy. And finally, step 5. Consult an employment attorney before signing any separation agreement or severance offer. Free consultations are widely available. Don't sign away rights you didn't even know you have. Before you go, I know this is a stressful situation. If you're watching this right now because you just got handed a PIP today, take a breath. You have more options than you think. Drop your situation in the comments. What did the PIP say? How long is the timeline? I'll read every comment, and those real situations directly shape what I'll cover in future videos. If this was useful, please subscribe. New video every Tuesday. And if you want to understand what your employer can and cannot legally do to you as an at-will employee, because unfortunately a PIP often leads to that conversation, I covered that in a full video. It's linked above. Worth watching before your next HR meeting. See you on Tuesday.